Your Honor, did you read the character references my neighbor sent you?
Do not.
The Mitchell.
Do not come here.
What?
At this hour.
In the pursuit of truth, we analyze the law. This is Justice Clash 24.
This sovereign citizen tried to show a picture in court, but the judge shut it down instantly.
Your name, sir?
Timothy Kelly.
I have two motions up. I have your motion to set aside the default.
Put the picture of my daughter here. She's an occupant. She wanted to be here to say something, but she was in school.
Okay.
Thank you.
That picture is not going to happen that way. You're not going to sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kelly.
Okay. Come on, Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in. Girls, I mean the nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have them.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right.
I thought they were both sent because I have a double thing where you could send group, and I sent them. At any rate.
Okay. All right.
Your Honor, I just, with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And, that's why I know I missed the trial, but there's all kinds of reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
I have read everything
Okay.
that comes in this.
All right. I didn't know. I'm just, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant-landlord disputes. That a judge could take a proactive role in the hearing by ensuring that both parties know.
What are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing, all the legal stuff that I read is that you try and work it out before the eviction case. And also I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up because.
Sir, you know what?
What? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Do not.
The Mitchell.
Do not come here.
What?
At this hour, questioning me
I'm not
about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here. They've been here. and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor. Please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're going to have a problem. Will you throw something down again, we're going to have a problem.
Sorry.
Retry this. Court recalls the case of River Ridge versus Timothy Kelly. This is your motion to set aside the default judgment. There are two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with a friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke, and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child. I don't want to put it on record yet because it has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've asked, that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And I've
Your Honor,
met,
I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that that conversation happened.
I thought at that time that it was a,
I'm not going back over this.
Your Honor, if you would listen to, if I could cross-examine witnesses and bring my witnesses in, you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, but it was a good reason. I want you to know the facts of the case. That's all.
The second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Kelly.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, and they're all filled up.
He claimed he missed court because of his daughter and serious personal issues. But when asked to explain his legal defense, this sovereign citizen struggled badly. The judge stayed focused only on law, not emotions or personal stories. And that's when the pressure inside the courtroom started building fast.
I think it's hard to even express because I'm afraid I'll offend you. And
sir, do not try to blame me.
I'm not blaming you
this
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me.
No.
Somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well, I had all kinds of things written down. I started to read it, and you said, "Don't read that to me." Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going to fill out.
Doesn't work that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial. The plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog. So she's added on without. So I'm just confused about the way to present evidence, I guess. You know, I mean, she brought up my daughter missing a day of school. Where did that come from? I mean, all
I
of
didn't
those have
mention
been,
his daughter at all, Your Honor. I'm sorry. When
it's
did
in
I
the,
mention his daughter?
it's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what
Sir,
happened there.
I need meritorious defenses you have to this claim.
You can't tell me what, may I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
I don't
And- Your Honor, while Mr. Kelly is retrieving his phone, I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious. Could you spell it for me?
No.
Okay. See.
You
Oh,
filed the motion.
yeah, probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay, suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well,
I have no idea.
is
what
it
that means.
moratorium? Oh, sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay. You can't. No, I was going to make. I think you should stay too. Go ahead.
when I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have arisen. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we do not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. If you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I will allow it to happen because I'm probably one of the most unfair judges I've ever met, but I'm going to try to be fair. Mr. Kelly,
Can I-
step away from the podium?
may I give you a
No,
compliment,
no,
please, Your Honor?
No,
Okay,
do not give me a compliment. Do not say anything to me at this
all
time.
right.
I'm gonna handle Mr. Fink's cases, Ms. Dornbush. Sooner or later, you'll be able to go
Okay,
home. She's gonna be mad at me.
I would never dare.
I tried. River Ridge versus Timothy Kelly. If Ms. Dornbush is.
I am still here, Judge, yeah.
I've called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, it was always, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I put in one of my letters that, or one of my motions that somewhere there's a phone call of that, because it was a three-way conversation, and I didn't know if I needed to look it up or not. But as far as the upon information belief and all those lists, please, I deny them, and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it, on the grass, but that was during the settlement conference. During what I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates, because the car wasn't running at that, but it had legal plates up until that point. So that's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given, that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornbush, your response.
Thank you.
Oh,
Your
I'm
Honor.
sorry, I don't have,
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
thank you.
Your Honor, at the outset, when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay. And that's not something my client is going to agree to. And I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system, and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well, because I do have his
Oh.
email address.
Okay, yes, well, you have the court's permission to do that, understanding what you
I
just.
don't have a problem.
Thank you, Your Honor. The specific issues that he put in, that I believe have absolutely no relevance to the issue of good cause is that, the court being aware of his transportation issue and is having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up, and he chose not to take the ride because of another reason, and we'll touch on that in a moment.
For more real courtroom breakdowns, subscribe now, because some cases aren't just about law, they're about real-life struggles. And in this moment, the judge had to decide based on rules, not emotions. Sometimes the system doesn't slow down for anyone.